The United States Department of Homeland Security is currently trapped between two completely opposite, legally binding federal court orders. A federal judge in Washington, D.C., has ordered the agency to immediately shut down specific functions of its national citizenship database. At the same time, a federal judge in Florida has ordered the agency to turn those exact same database functions back on immediately. At the center of this conflict is the Systematic Alien Verification for Entitlements, or SAVE database. This system processes a wide array of sensitive documentation, from residency cards to U.S. passports. For 4 Republican-led states, Florida, Ohio, Iowa, and Indiana, this database is a primary tool for finding and purging suspected non-citizens from their election systems. But civil rights groups warn the system risks wrongfully disenfranchising naturalized citizens and exposes the private records of 67 million Americans. The final result is a complete legal deadlock. No matter what action the federal government takes next, it is guaranteed to be in contempt of a federal court. This crisis began in 2024 and 2025, when Republican states sued the Biden administration, claiming it was deliberately hindering their ability to verify voter citizenship. To address those concerns, the Trump administration issued a March 2025 executive order to overhaul and upgrade the SAVE database. The upgrade changed how the system functioned, adding bulk uploads and the power to search using partial Social Security numbers. This alarmed privacy advocates. They argued the upgrade centralized previously isolated, highly sensitive data, like tax records, medical history, and biometrics. This split the legal fight into 2 tracks. In November 2025, the Department of Homeland Security signed a settlement in Florida, legally promising the GOP states it would keep these bulk search and Social Security features active. Meanwhile, civil rights groups filed a separate lawsuit in D.C., arguing these exact upgrades bypass Congress and violate federal privacy laws. The agency had essentially boxed itself in. DHS voluntarily signed a binding settlement in one jurisdiction, guaranteeing the exact technological behavior that was being prosecuted as illegal in another. On June 22, 2026, the D.C. judge issued a summary judgment, ruling that the SAVE upgrades had violated American privacy rights. The court ordered DHS to immediately disable the bulk upload and Social Security search features. DHS complied with the order, functionally shutting the tool down for the states relying on it. The Republican states immediately petitioned their judge in Florida, arguing the federal government had broken its November settlement. The Florida judge then issued a counterstrike. He ruled that DHS had violated the agreement and ordered the agency to reinstate the features immediately. In his ruling, the judge stated that his court was absolutely not bound by the order issued in D.C. By July 2026, the federal database was paralyzed. The U.S. legal system allowed 2 judges of equal rank to issue mutually exclusive commands. This gridlock is the result of a specific structural element in the U.S. judicial system, district court jurisdiction. A single federal district judge has the power to issue an injunction that impacts the entire nation, but because peer judges in different districts are not legally bound to respect each other's nationwide orders, those commands can collide. DHS is now petitioning 2 different appellate courts, the 11th Circuit and the D.C. Circuit, seeking a tiebreaker. Because this involves 2 different circuits, the crisis will almost certainly require an emergency intervention by the U.S. Supreme Court. The stalemate over the SAVE database shows that national policies, from election security to data privacy, are increasingly governed by the overlapping, contradictory orders of individual federal judges.